Today we will see juridical acts. Juridical acts are actions which have legal effects. All legal actions which are voluntary and have legal effects are considered to be juridical acts. Like for example, making a contract, selling a house, making a donation, writing a last will, or getting married. These are all examples of juridical acts. On the contrary, going out with your friends, watching a movie, making a joke, these are not juridical acts because they don't have any legal effects. According to Section 149 of the Civil and Commercial Code, juridical acts are voluntary, lawful acts which establish between persons legal relationship. This includes creating a right, like for example when I hire you, I create a right. Modifying a right, like I increase your salary, I increase the salary of my employees, I modify their rights. Or I can transfer a right when I sell my house, I transfer the ownership of my house from me, the seller, to the buyer. I may also preserve a right, like for example, suppose you borrow my money, I may ask your gold ring as guarantee to preserve my right. If you don't give me the money back, I will sell your ring. Or terminating a right. In the example I mentioned before, I hire you as my employee. If one day I decide to fire you, well, in this case, I terminate your rights. Juridical act is made of several elements. There must be, first of all, a declaration of intention. If, for example, I want to sell you my house, I must communicate this intention to you. I cannot keep this intention inside my mind. Second point, voluntary act. There must be voluntary decision to make a contract. If the decision is not voluntary, this would be wrongful act. And then the act must be lawful. I can decide to sell you my house. I can decide to sell you my bicycle. I cannot decide to sell you my finger or my leg. And the last point, as we already explained before, juridical relationship. It must create juridical relationship. If I just say, do you want to go out with me tonight to watch a movie? You answer yes, and then I don't show up, I don't come with you. You cannot sue me because this is not a juridical act. This invitation does not create any juridical relationship. Juristic acts can be divided into different categories. Unilateral and bilateral. What does it mean? Unilateral, it means juristic acts which are created by one person. Like for example, declaration of birth. I have a baby, I go to the local umpire to declare the birth of my son. Or if I sue someone, I don't need the approval of the person we sue. Bilateral is different because bilateral juristic acts are acts which are created by at least two persons, like for example, contracts. Then the second difference is between inter vivos, mortis causa. Mortis causa are all those acts which create effects after the death of a person. Like for example, donation. I decide to donate my money after my death to my best friend. This is mortis causa because the death of a person, my death, is an essential element in order to produce the effects. All other acts are considered to be inter vivos. Third difference is between onerous and gratuitous. Onerous means that one party gives something to another party and at the same time receives something. Like for example, you buy my house, you give me money, I give you my house. This is onerous act. Gratuitous is different. Gratuitous means that only one party gives something to the other party. Like for example, in the case of gift, I give you something in exchange of nothing. Then we have acts which require a specific form and acts which do not require any form. Specific form can be registration, can be written form. The same example I used before, when you buy a house, you must have a written contract and you must register the contract to the land office. This is very different for a contract of purchasing a bicycle. You don't need any written evidence, you don't need any type of registration, because when you sell movable property, you don't need any special form. And the last is principal and accessory. Principal mean an act, a contract, which does not require any other act. Like for example, I sell you my house, I don't need any other act. This is different from accessory contracts. Accessory contracts are contracts which rely on the existence of other contracts. Like for example, you rent my house and you say, if I don't pay, my brother will pay. The obligation of your brother is called suretyship. Your brother needs to pay only if you don't pay. It means that the obligation of your brother is accessory. It is based on your obligation. If one day you decide to move abroad, not to rent my house anymore, automatically the obligation of your brother will cease to exist. There are different elements of the Juridical Act. The first one is the capacity of the actor. The actor must have the mental ability to enter into contracts, to perform a juristic act. There must be an intention, form, and object. Capacity in Thailand is 20 years old. It means that if you're not 20, you are not sui juris, you are considered to be a minor. Your juristic act, your contract, is considered to be voidable, not valid. In order to create a valid juristic act, there must be an intention. It means voluntary intention. The intention is analyzed objectively. It means that the law does not care about what is inside your mind, what is the subjective intention of the parties. The law wants to know what is the objective manifestation of your intention. If your hidden intention was different from the objective manifestation of your intention, the law will consider the objective expression of the intent. Let's illustrate this point with an example. Suppose that I say, do you want to buy my MacBook Pro 2011 for 20,000 baht? Then if you say yes, I cannot change my mind and say, I'm sorry, my meaning was different. I meant Sony laptop, or I meant a different price. I didn't want to say 20,000 baht, I want to say 15,000 baht. Simulation. Simulation is defined as a juridical act which does not reflect the true intention of the party. It can be absolute when the parties they do not want to enter into any type of contracts. Like for example, suppose I have a lot of debts, 50 million baht. The creditors are going to go to court, they are going to sue me, and they are going to sell my house. I don't want to lose my house, I just pretend I sell my house to my cousin. So the creditors will not be able to get my house, to sell my house. This example of contract of sale is a simulation. It means that it is not valid. Simulation may also be relative. When parties they just pretend they make a contract, but actually they are hiding another contract. Like for example, I pretend to donate my house to you, but actually I'm selling my house to you. We just pretend this is a donation, this is a gift, so we will pay less taxes. In some situations, the juristic act is not valid. In particular, in case of mistake, fraud, and duress, the juridical act may not be valid. What is a mistake? A mistake is an error when a party's belief is not in accord with the reality. Suppose I buy your land, in the title deed, in the channot, it's written that your land is 3 rai, but actually in reality it is 2 rai. Well, this is an example of mistake. So this juridical act, this contract may not be valid. Fraud is a dishonest behavior of a party. It is used to deceive the other party. For example, I lie to you. I say, do you want to buy my dog? My dog has won many competitions. It is the first dog in Thailand. It is the fastest dog in Thailand. But this is not true. So you are paying a very high price for this dog, and then you find out that I lie to you. You can cancel this contract because this contract is voidable. Last, duress. Duress means when a party induces the other party to make a contract through unlawful threats. For example, I say, if you don't sell me your car, I will kill you. Or, if you don't sell me your car, I will tell everybody that you are cheating on your wife. In case of duress, the Juridical Act is not valid, is voidable. Another essential element of Juridical Acts is the form. Form, as a general rule, is free. It means that parties, they may decide to use the form they want. They can decide to make a written contract or just a verbal contract. They may decide to make a contract just based on their behavior. Like, for example, when I go to the 7-Eleven, I may just take a can of Coke and give 20 baht to the seller without mentioning, without even speaking. This is based on the objective manifestation of my behavior. In some situations, however, the law requires special forms. Like, for example, when you get married, you need a special form. When you buy a house, you need a special form. When you set up a company, you need a special form. If the law does not require a special form, it means that you are free to use the form you want. You can decide to write a contract, you can decide not to write a contract, it is up to you. The object can be decided by the parties. However, Section 150 of the Civil and Commercial Code says that the object cannot be prohibited by law, impossible, contrary to public order or good morals. It means I cannot sell you my brother. This would be prohibited by law. I cannot sell organs. I cannot sell something which would be impossible, like, for example, I sell you the moon, I sell you the sun, I sell you the stars. The notion of impossible will change depending on the state of technology. Something which may be impossible today may become possible in the future. Then the contract is also void if it is contrary to public order. What is public order? Public order, it means that the society must function efficiently. So, for example, if you get married with 3 women, this marriage would be considered as illegal because its object is against the public order. Similarly, if I say, if you vote for me, I will give you 2,000 baht. This contract would be against public order. Then, contrary to good morals, suppose I say, you write a last will in my favor, and I write a last will in my favor. If I die, you will inherit everything. If you die, I will inherit everything. Similarly, if I say, I hire you as my employee if you decide to live with me, this contract would be against to good morals. Some elements of the Juridical Acts are not necessary. Parties, they may decide whether they want these elements or not. These elements are condition and time limitation. What is condition? Parties may decide that their contract or their Juridical Act is subordinate to a condition. The contract will be effective only if a specific condition is fulfilled. For example, I say, I give you 1 million baht if Thailand wins the World Cup. This is a condition precedent. In other words, only if this condition is fulfilled, only if Thailand wins the World Cup, I will give you 1 million baht. Condition subsequent is different. For instance, I can say, you can live in my house until my son graduates. If one day my son graduates, this condition will terminate the effect of a juridical act. Only when my son graduates, you need to leave my house. In other contracts, parties decide to include a time limitation. For example, I hire you starting from the 1st of January 2018. It means that our employment contract will take effect in a specific day in the future. Or I can say, you can work for my company until the 31st December 2018. It means that on the 31st December 2018, our contract will terminate. The difference between condition and time limitation is that for conditions, we are not sure whether the condition will be fulfilled or not. We are not sure whether this future event will happen. For time limitation, we are sure. We are sure that 1st of January 2018 will come. We are sure that the 31st December 2018 will come. So it is a future event, but we are sure that this day will arrive. Throughout this presentation, I mentioned the word void and voidable. Now you will understand the difference. Void means a juridical act, a contract is not valid at all. There is nothing you can do to change this. When, for example, I say, I sell you my finger, I sell you my brother, this contract is void. There is nothing you can do to change this. It has no legal effect at all because it is against the public interest. Voidable is different. Voidable means that the contract, the juridical act, is contrary to a private interest of one party. There is one weak party which is protected by law. Like in the case of fraud, I am victim of fraud. It means that my contract is voidable. Only the weak party, only the victim of fraud may decide whether this contract should be cancelled or ratified. When you sell me the dog and you lie, you say that this dog is a very good dog, is the fastest dog in Thailand. After I buy for a very expensive price, I may decide whether I ratify the contract, I make the contract valid and I keep the dog because I really like the dog even if I pay a very expensive price, or I may decide to cancel the contract because your dog was overpriced. So I may decide to cancel the contract. I don't want the dog anymore, I want my money back. Only the weak party can decide whether the contract should become valid or cancel. The contract may also be unenforceable. It means that the juridical act, the contract is valid, but in case of breach, parties, they cannot go to court. You will understand this difference later when you will study specific contracts. Thank you for watching.